Hello, everyone. I can see people slowly coming in. Welcome. Hi, everyone. Welcome. We're just gonna just allow everyone to come in for a moment before we start. So just bear with us just a minute or two before we get going. I can see names I recognise, which is lovely. Lots of people that are coming in, everyone that's joining us in September, which is great. Always nice for me when I see names that I recognise as well. Okay, I'm just going to check the settings are all working okay. Perfect. Yep, all looks good. Brill. I can see the number ticking up as well. Okay, I'll start with the introductions, then we'll get started in just a moment when I hand over to Miriam. So welcome everyone. Thank you for joining us today. If you haven't met me before, many of you I know will do because I recognise lots of names. My name is Charlotte Burton. I'm the marketing manager for the School of Law here at Queen Mary. My role is to give you opportunities to meet colleagues of mine like today with Miriam joining us, but be able to ask questions ahead of joining us. And most of you, if not all of you, will be offer holders that are joining us this coming year, which is really exciting. So welcome. It won't be long before you'll be here with us in London, which is great. We really look forward to meeting you. Today's session is a research showcase, which is quite exclusive, something that we don't normally offer, but we've done this exclusively for you as offer holders that are coming to join us as an insight into some of the research that we offer. And Miriam is the perfect person to go through this, so I'll hand over to her in just a moment. Once Miriam's finished doing her presentation, we do have some time for questions. So if you do have any questions, please feel free to use the Q&A and we will go through those. At the end, we're also happy if you want to put your hand up to talk, and we can allow you to talk on the webinar here to ask your question verbally as well. We like to try and keep things interactive if we can. So please use that function. I will monitor that as we go along if there's anything that's unrelated to this and you have other questions. If not, I'll also put my email address in the chat afterwards. So if you've got any questions at all that we haven't been able to get to, you're able to ask those as well. Okay, so without further ado, Miriam, I will pass over to you.
Thank you very much, Charlotte, and welcome everybody. It's very nice to meet you for the first time, and hopefully I'll be seeing quite a lot of you once the academic year begins. So as Charlotte said, my name's Miriam Goldby. I'm a professor of insurance, shipping and commercial law at CCLS. And Charlotte kindly invited me today to talk to you about my research. So I work on various different fields of research. But what I thought I could talk to you about today is a line of research that has been ongoing for the past 20 years, September 2003 to be exact, so 21 years now, which has led to the adoption of a model law by the United Nations Commission on International Trade Law, UNCITRAL, and to an act of parliament in the UK, which came into force in September last year. So I'll talk to you a little bit about this research. It started with my PhD thesis and carried on into a book and several publications which came to the attention first of the UNCITRAL Secretariat and then to the Law Commission in the UK. So I'll start with a bit of background. So as you can see there, this gives you a little bit of a visual overview of what has happened over the past few years. So this is a copy. Well, it's the front cover of my book, the second edition of my book. The first edition was published in 2013 and the second edition in 2019. And in this piece of research, which was based on my PhD thesis, I was looking into what the legal obstacles were to transitioning from paper documents to electronic documents in the maritime field, in the field of transportation of goods by sea. And I'm going to explain in my presentation why it was so important and why it was also legally so complicated to move from having paper documents to having electronic documents for this specific kind of document. So a few years after so a couple of years after I finished my PhD thesis, I was asked to become engaged in an UNCITRAL project, which started in 2012 and finished in 2017. And the result of this project was a model law in order to give countries, to give nation states a model, if you like, in order to update their laws, to remove the legal barriers that I talked about in my PhD. And one of the first countries to do this was the United Kingdom. So I joined the Law Commission of England and Wales in order to undertake this research project, which was focused on finding out exactly what needed to change in English law, in UK law, in order to remove these legal barriers. And this project led to the adoption of the Electronic Trade Documents Act 2023. Now, as you will all be aware, what happened during that time period was the COVID-19 pandemic. So essentially, when UNCITRAL adopted its model law, it was 2017, and the model law was adopted, and essentially for a few years, nothing happened. But in 2020, as you all know, COVID happened, and it became extremely difficult to process transactions that were based on paper documents. And it was because these paper documents could not reach the people who had to check them and had to undertake the verifications needed to make payments, to keep the transaction going. So when all this became, when it became really evident that international trade was stalling, it couldn't carry on without digitalization of these documents, the G7 in 2021, the G7 is the group of 7 nations, committed to adopt a legal framework compatible with the UNCITRAL model law in order to facilitate the carrying on, if you like, of international trade in a digital space, which it couldn't do using paper-based documents. And in last year, so earlier this year, I was nominated for an award by the trade community to reflect the contribution I had made with this research to the digitalization of international trade. And this is because, as you can imagine, this is very, very high impact work in terms of society and the economy, because it has the potential to facilitate international trade and make it happen more smoothly and efficiently. So I'm going to start my my showcase, if you like, my research showcase, by explaining why we needed these pieces of legislation. What are the barriers we are dealing with here? Why can these documents not be digitalized in the same way as other documents, other paperwork, which has been digital for many decades now? Well, existing e-commerce legislation prior to the model law of 2017 was not sufficient to remove these barriers. What did existing e-commerce legislation do? Well, it recognized the legal effect of electronic data and electronic communications to do two things. First of all, they were effective to form binding agreements if the contract formation requirements were met. So you could make contracts using electronic communications just as easily as you could using writing. Secondly, you were able to satisfy certain formal requirements. For example, where information is required to be in writing or signed. Those things were already done. We had been able to do those things for years. Satisfy a writing requirement using digital data and satisfy signature requirements using digital data. So even pre-reforms, a signed document could be created and issued in electronic form. But the types of documents we're talking about are different. They are different because for two reasons. First of all, not only does the document evidence legally relevant facts and or intentions. So this is one thing the document does, just like any other document. It evidences legally relevant facts and or intentions at a particular point in time. But it also does another thing. It also provides evidence of who has the right to claim performance of the obligation recorded in the document, in a situation where that right is being transferred from person to person. What does this mean? Let me give you a prime example, which is the ocean bill of lading. So when I put goods on board a ship because I want to send them to my buyer, the carrier of the goods, usually the ship owner, will issue a document that says, I have received from Miriam these goods of this description and this quantity, and I have promised to deliver them at this destination. So there you have the carrier creating a legal obligation, the obligation to deliver the goods to this destination. Now, what the document will also say is that the carrier will deliver the goods to the person I tell the carrier to deliver to. So essentially, by taking this document and handing it to my buyer, I am creating a right for the buyer to claim the goods from the carrier. So what we have here is not just a document that tells you what the legal obligation is, it is also telling you to whom the obligation is due through possession of the document. So because my buyer is the holder of the document, because the buyer is in possession of the document, they can claim the goods from the carrier. Now, this means that by using these documents, transactors avoid the need to create a new document every time the person who has the right to claim performance of the obligation changes. You don't need a new document, you just need to be able to show that you have possession of the document. So transfer of the document achieves a legally recognized transfer of the right itself, the right to claim performance of the obligation. So possession of the document provides reliable evidence of who has the right to claim performance of the obligation recorded in it. So this is where the issue is. You need possession of the document. And this is a challenge because the laws of most jurisdictions recognize only tangible things as being capable of possession. So what you need to solve is this possession problem, which isn't solved by existing e-commerce legislation. So how do these pieces of legislation solve the possession problem? So let's have a look at the substantive provisions. Don't worry too much. This isn't going to be like a full-blown lecture because there aren't a huge number of provisions. So first of all, in the MLETR, you start with definitions. So Article 2 says, for the purposes of this law, transferable document of instrument means a document or an instrument issued on paper that entitles the holder to claim the performance of the obligation in the document and to transfer the right to performance through the transfer of that document or instrument. So it's very clear what we're talking about here. We're not talking about just any document. We're talking about documents that function on the basis of possession. And you can see that the same applies in Section 1 of the Electronic Trade Documents Act. So basically what the Act does that is slightly different from the model law is it gives you a list of examples of documents that could be trade documents. And you can see there, all of them would entitle the holder either to claim goods, the delivery of goods from a carrier, or to claim payment of a sum of money. That's the bill of exchange and promissory note. Those are called negotiable instruments. Or to claim compensation or a payout against an insurer. And this is very important because when goods travel, they are almost always insured. They have to be insured because transportation, especially transportation by sea, is very risky. Now, this sort of summarizes what I have said already. Basically, essentially, they both talk about the same kind of document, and they are all documents where possession of which is important. It is relevant for legal purposes. Now, this is why possession is important. You will see that the person who is able to claim rights is the lawful holder of this type of document. And being a holder requires you to be in possession. So you have to have possession in order to be holder. Without possession, you're not the holder. So this is why it's so important to solve the possession problem. Now, what makes an electronic transferable record? So what requirements does this electronic document have to satisfy in order to be recognized as equivalent to its paper counterpart? So what makes an electronic bill of lading? So first of all, you have to have information in electronic form. Okay? Now, this information has to be of two types. First of all, you need the human readable information that constitutes a document of this type. So as we said for a bill of lading, you need to have a description of the goods, you need to have a promise by the carrier that they will deliver the goods to a certain place. And you need to have certain factual information all recorded. Secondly, you need to have a data structure. So besides having the human readable information is not enough by itself. You also have to have logically associated information, which gives the human readable information a structure. If you think about it, a piece of paper gives human readable information a structure. It gives it a form of some permanence. So you can see also in the Electronic Trade Documents Act, you have the same two elements. You have the human readable information that constitutes a document of that type, and you also have logically associated data. So what is a data structure? As I said, a method must be found of giving a structure of some permanence to information in electronic form as paper does. Now, what this structure does is it gives that information an identity. It gives it, the other way of putting it is that it gives it an independent existence. Now, you can do this in the electronic space through something called cryptographic hashing. And basically, it's a way of generating a code that is unique to that data set, that human readable information. Now, if you're using, there are different types of technologies you can use. One of them is distributed ledger technology. It's the same technology used for Bitcoin, so it's blockchain technology. And if you're using DLT, what you do is you generate a token that is associated with that human readable information. So unique token that gives it its own identity. Now, what are the criteria that you need to satisfy? So you need to have the human readable information that constitutes a document of that specific type. Then you need to have the data structure. Now, what does the data structure need to be able to do? First, it needs to give, as we've already said, that electronic information and identity. So identify it and make sure it's identifiable from any copies of the human readable data. To make it capable of being subject to control, obviously, because a very important element of possession is control. It's an essential element of possession. And finally, to retain its integrity, because this is the other feature of paper documents. They are made by making permanent marks on a physical medium. So if you see when you look at a paper document, it should be pretty clear whether it's retained its integrity or it's been tampered with. And then paragraph 2 there is defining integrity. And you can see that the criteria to be met under the Electronic Trade Documents Act are quite similar. Again, you have identity, you have integrity, you have control, capable of exclusive control. So this slide gives you a summary of the main requirements under each piece of legislation. And it shows you how they mirror what paper does for paper documents. Now, what does control mean? Because control, as I've just said, is central to the whole idea. Because control is what makes, what provides an equivalent of what happens when you're in possession of something in the physical space. So, as you can see in the MLETR, essentially, you are meeting requirements, legal requirements for possession, if you are able to establish exclusive control over this document, and essentially, if it is clear, you can show that you have control. You also need to be able to transfer control. And once you transfer control, your transferee will be the person in possession. So we're mirroring what happens in the paper world through the device of control. And through the device of control, we are satisfying requirements in the law for possession. And you can see that it's the same, it's very, very similar under the Electronic Trade Documents Act, except the Electronic Trade Documents Act refers to the idea of exercising control, not having control. And this is in order to adapt the law to the specific situation under English law, where possession is composed not just of physical control over something, but also what we call animus possidendi, the intention to possess. So by talking about exercising control, the ability to exercise control, and the divestibility of the document once control has been exercised, we are preserving that idea of intention, the intention to possess. And you will see that Section 3 of the Act says that if the criteria to form an electronic trade document are met, then it is capable of possession, just like a paper document. And this again summarizes everything I've just said. Control refers to a state of fact, not a legal right. Okay, so having control is equivalent to having physical possession. So it's a question of fact. Once you've established that you have control, then you will look at the circumstances to see whether this amounts to a legal right. But it's the same, exactly the same for a paper world. You can be in physical possession of a piece of paper without actually having the legal right to it. In the MLETR, the language of functional equivalence is used. So the language of functional equivalence is if the law requires, that requirement is met. So we saw with the MLETR, where the law requires the possession of a transferable document or instrument, that requirement is met. So that is the language used in the MLETR. The language used in the ETDA is different. Basically, the ETDA is saying, provided the criteria, the gateway criteria in Section 2 are met, you can possess, a person can possess and part with possession of an electronic trade document. Now, the language was changed, and the language was changed to reflect the specific requirements of English law. However, both pieces of legislation seek to plug into the legal framework that is based on possession. So they are both changing as little as possible. They are saying to the world of international trade, the participants in international trade, you can use these electronic documents in exactly the same way as you use paper documents, provided you meet the criteria. Now, there is reference in both pieces of legislation to reliability. Okay, you will see here a reference to a reliable system. Okay, that's in the Electronic Trade Documents Act. And you will see here a reference to a reliable method. Okay, so how do you determine whether the method or the system is reliable? Remember that reliability is something that is going to be tested with regard to any document if you want to produce that document as evidence of your rights, evidence of your claims. So reliability is key to these documents. And essentially what both pieces of legislation do is they set out a list of indicators of reliability. So what does the court look at when they want to determine whether the system or the method is reliable? And you can see it's all about how good the electronic system is, the computer system that is used to generate and transact in these documents. You will see a very, very similar list in the Electronic Trade Documents Act. Now, how do the approaches to reliability compare? Both of them use the language of reliability and list similar indicators of reliability while maintaining technology neutrality. This is very important because we know what technology is available today that might be reliable, but we don't know what technology will be available tomorrow. So it's very important to keep the law relevant by not limiting it to a specific technology. Both lists are couched as guidance to dispute resolvers in determining whether the method or system used to meet the criteria was sufficiently reliable. However, they can also be used by system providers in designing systems and by prospective system users in selecting a system to use. So essentially, these are the benefits of setting them out in advance in the law. Now, the MLETR does contemplate a scenario where reliability does not need to be proven. Okay, so it says here, you can prove that the system did what it was required to do, rather than proving that it is reliable. However, the Law Commission decided not to include that for this reason. Including such a provision could produce an unintended result in that where the system could be shown to have done what is required in a particular case, the system's reliability would not need to be assessed. So what the Law Commission wanted to do was avoid this impression that the system might not need to be reliable. It is it is important that every system is established as being reliable, and there is the opportunity for the court in each case to assess the reliability of the system. Now, what if paper is required somewhere down the trade chain? So both pieces of legislation provide for the change of form or change of medium between paper and electronic. And this is because these documents are used in international trade transactions where the goods are moving from country to country. And if your buyer is situated in a place that doesn't accept electronic documents, where, for example, the customs authorities at the port, they want to see paper documents before they are ready to let your goods through, you should be able to switch from electronic to paper. And you'll see that the ETDA also does this. Now, there's one difference between the ETDA and the MLETR. The MLETR actually requires specifically that the old document, the one which is being replaced, is made inoperative. Okay, so this is what the MLETR requires. The ETDA, instead of saying that you have to make it inoperative, it is saying that you have to comply with any contractual or other requirements relating to the conversion, i.e. replacement of the document. Now, this is because the person who issued the document is very likely to say the condition for allowing you to change medium is that the old form of the document is taken out of circulation. Otherwise, I might become liable to two people, one person holding the paper document, the other person holding the electronic document. And this again summarizes what I've just said. And in the next couple of slides, I have included some information on why the Law Commission decided to go in a slightly different direction from the MLETR on this particular point, although the differences are not significant. Now, there are other provisions in the MLETR which again aren't reflected in the Electronic Trade Documents Act, and this is because they are covered elsewhere already in English law. And this really emphasizes how important it is not to take a model law and simply turn it into an act of parliament. It's very, very important to see what impact its provisions are going to have on existing law. Now, the Law Commission had two very important priorities when it was adopting the Electronic Trade Documents Act. First of all, minimum intervention. Let current law don't change it any more than is necessary. Leave it the same because this is what people are used to. These are the this is the framework within which they are used to transacting. And secondly, make it as easy as possible for the users of this legislation to adapt to it. Essentially, make sure it is that the resulting electronic documents can be used insofar as possible as similarly to their paper counterparts as possible. And secondly, maintain technology neutrality because better solutions might become available in the future. Now, these are the lessons learned, and I think these are really important because many countries are already transitioning, are already adopting laws to enable digital transacting in international trade. And more countries will be doing this in the future. But as I said, it has to fit properly within the existing legal framework. And these are the areas of law of which you need to take account when you are undertaking reforms. So the law relating to negotiable instruments, the law relating to documents of title to goods, sales law and contract law more generally, trade finance law, and law relating to credit and security, including financial regulation. This broadens the field quite a lot. Marine insurance law on assignability of documents, applicable international conventions with potentially conflicting provisions. This was an important one because, for example, on negotiable instruments, we have the Geneva Convention, and the Geneva Convention does not contemplate negotiable instruments in electronic form, case law providing statutory interpretation, and the frameworks underpinning existing electronic systems and potential conflicts. So you have to take all of this stuff into account, and it's not as easy as simply adopting a model law, although the model law was designed to be as broadly applicable as possible. Now, I've prepared a couple of slides on the reliability requirement because this is precisely the area where more research may be needed and where it's pretty important to the industry to understand exactly what constitutes a reliable system or method. But I see that we've already spent quite a lot of time discussing these things. So I'm happy to take questions at this point if you'd like, or if there aren't any questions, I can go ahead and talk in a little bit more depth about reliability.
There's no questions on there at the moment, so
There's no questions.
carry on.
Okay, no questions is a good thing. Okay, so let's talk about reliability. Reliability is a standard applicable to electronic systems and processes, which is not new. It has been around for many decades already, starting with the Uniform Commercial Code in the US. It is found in the 2005 Electronic Communications Convention, and in other, as well as in other UNCITRAL texts. It's also found in the law in Australia, Singapore, etc. So it's not something new. It has been used before, but it has not received as much attention before as it is doing now. And the reason it is receiving quite a lot of attention now is because this is the point at which international trade is transitioning to digital methods of contracting, transacting, communicating. Now, reliability did not previously feature in UK statutory law, but system reliability has been discussed, sometimes at length in the case law. So one very, very important case is the case of Bates and the Post Office, which involved hundreds of what are called sub-postmasters who had a contract with the post office to use the post office accounting system called Horizon. And this was an electronic accounting system which proved very unreliable. And thanks to this unreliability, these sub-postmasters, some of them were found guilty of criminal offenses and even went to prison because essentially there were massive accounting errors on their accounts and they couldn't prove that it was simply a system error. It was not them defrauding the post office. So this case really highlights how important it is to use reliable systems. Requiring a reliable system to meet the gateway criteria is justified in that the use of certain trade documents can have erga omnes and effects, and not exclusively as between commercial parties. So what does erga omnes means? It means it can have effect vis-a-vis the whole world. Why? Because here you are talking about rights. You are talking not just about contractual rights, but also rights over goods. Rights you can enforce against no matter who is currently in physical possession of the goods. So it's really, really important that these rights are based on reliable evidence, reliable documents. A reliability standard can increase the perception of trustworthiness and the confidence in electronic trade document systems, and this is required to secure widespread digitalization. Because if these systems prove unreliable, you're not going to get the desired effect, which is more widespread use of electronic alternatives to paper documents. But the absence of a means to ascertain whether a system is in fact reliable in the sense required by law can create uncertainty and delay adoption. So essentially what is needed is more guidance for industry as to what would satisfy the legal requirement for reliability. Now, when Singapore adopted the model law on electronic transferable records, one adaptation they made was to include an accreditation process for electronic systems, accreditation of these systems as reliable. So if you wanted to, you could apply to have your system accredited as reliable, making it easier for participants, for users to choose your system, because they could have a certain amount of reassurance that it would satisfy the legal requirement for reliability. However, bear in mind that in the Singapore Act, this presumption of reliability, if you were an accredited system, was rebuttable. So if your system did not behave in a reliable way, then you could rebut the presumption. The presumption of its reliability could still be rebutted. Now, the Law Commission of England and Wales decided not to go along with this idea of accreditation for two reasons. First of all, there is a big burden on the state if it has to provide an accreditation system. So that is not a decision for the legislator, it is a decision for the government. The government has to be prepared to set it up and carry the burden of providing the accreditation system. Secondly, it also means that if every country had an accreditation system, because international trade is international, if you wanted to provide an electronic trade document service internationally, you would need to get accredited everywhere. And this is, of course, going to be very expensive for system providers, and those costs would be passed on to users. So this creates a conundrum. On the one hand, providing for pre-accreditation and the reversal of the burden of proof upon such accreditation being obtained increases certainty and reduces the upfront costs of digitalizing for businesses. On the other hand, setting up an accreditation system on a national basis requires the state to defray considerable upfront costs. It is challenging in the absence of an internationally agreed reliability standard, and it creates further costs for businesses unless there is a mutual recognition framework. So, basically, this is a field where further research is required. What is the best way to address this conundrum, to address this issue, that reliability may end up slowing down digitalization? So that was it from me. That was all I had prepared for you today. I will stop sharing the screen. And Charlotte, do tell me whether there are any questions.
Hello. So there isn't any in here, but we may get some come through. So if anyone has any questions, please feel free to jump on and put something in the chat. It might also be helpful, Miriam, to explain how research informs all the teaching at CCLS. Because I know that
absolutely.
whatever you do, this will inform your teaching, I'm sure.
Most of us at CCLS are able to offer courses based on our research, and many of these courses are unique. They're unique to CCLS because we're basically the only people doing this kind of research. So when the government asked the Law Commission to undertake this project, the Law Commission came to me straight away and they asked me to join their team on a part-time secondment, because essentially the expertise required meant that there were very, very few people able to do the work, the preparatory work for coming up with the right piece of legislation for the UK. So I had been teaching this subject at CCLS since I joined in 2012. So I introduced the subject for academic year 2013 to 2014. And since then, CCLS is basically the only place where you can get a dedicated module on this particular subject. Now, it isn't offered every year because I teach a lot of modules, and I'm not going to be around in term one of this academic year. But even in years when I don't teach it, I still offer a 3 hour, extra lecture for our students so that they are prepared on this subject matter. Because if you're going to be working in the field of international trade or shipping law, you are going to need to be aware of these developments. They are at the moment still new, but they are going to become very, very important and relevant and a big part of your job. So it's really important to me that our students have, they're ahead of the students in other universities when it comes to preparation in this particular area.
Absolutely. And of course, it's the same for all the research that takes place at CCLS. As your role as research director, I guess you're across a lot of it.
Yes, so I'm research director at CCLS. So essentially, my job as research director is to create a positive and supportive research environment for all of us to be able to meet our research objectives. That is, do the research we want to do and make the contribution we want to do. So um, a few things that you might be interested to know about research at CCLS. First of all, a lot of it is very high impact, what we call high impact research. So a bit like my research, it translates into real world results. You can see the effect of our research in legislation, in policy making, in schemes that get set up to deal with specific problems, in regulation, in court decisions. Our research is often cited by the courts when they are deciding disputes. So you'll see that you'll be exposed at CCLS to people who aren't just teaching out of a textbook, right? They're there to open your minds to very cutting edge developments, and also to take a critical approach to the law. What does the law do? What does it need to do? What is it not doing well that needs to be done better, and why? So it's very much the kind of program where you will be asked to, well, your aim, our aim rather, is to give you different ways of thinking about the law and different ways to find things out that you want to find out. So you won't just be getting theoretical foundations on which you can build by yourselves. You'll also be getting the skills you need to build on that by yourselves. And it makes for graduates that are very, very attractive to future employers, because they will want to appoint people who can make a difference, who aren't just there as pen pushers. You need to be able to think creatively about the law and to yeah, be critical and evaluative in your approach to it.
Brilliant. Thank you, Miriam. So looks like you've answered everything really well because we haven't got any questions, or we've got a very shy audience.
Okay. Does anyone have any other questions, for example, on dissertations, on the various modules, on module combinations, perhaps, and how to make your choices, etc., etc.?
Yeah, I guess any advice that you have for the students incoming is always nice for people to hear.
Yes, so I mean, there are many differences among students, right? A lot of them are here because they want specialist knowledge in a specific field, because they want to work in that field. Others are here because, you know, they want to get something more than they did in their undergraduate degree in terms of skills, you know, analysis, evaluation, critique of the law. And then others still aren't really sure what they want to study, but they know they want, you know, to delve deeper into the law, and they're open to ideas when it comes to which field to specialize in. So we have something to offer for all of those kinds of students. I mean, if you're not sure what you want to study yet, I would say go for topics that really interest you, because those are the subjects where you're likely to do very well. And one thing that's going to really help you get a good job after you graduate is excellent grades. So, you know, just go for a topic where you know you're going to enjoy spending time with that topic, because it is very demanding, right? Preparing, doing the assessment, doing well in the assessment, it's not easy. I mean, if it's easy, you're not doing it right. Okay? If you're doing it right, it should feel difficult, because learning new things is difficult. It requires effort. It requires concentration. It requires dedication and time. So do choose subjects that you're passionate about, or that really interest you, that spark your curiosity, because that's what's going to make you want to spend time on them.
Perfect. I think that's really good advice, Miriam. Okay, quiet bunch. So I think we can close it off early, and that's totally fine. And because a lot of people I know usually join in lunch breaks or take time. So Miriam, thank you so much for your time today. It was
Oh,
really
most
interesting,
welcome.
particularly for me as well, sitting in the background listening was very interesting. I actually thought to myself that my father-in-law, I'm going to send him the recording because he'll find this very
Oh,
interesting.
good. Okay.
So thank you so
Okay.
much for this. Thank you everyone for joining. It's only a few weeks till you'll be joining us here in London. So make the most of your last few weeks, and we'll look forward to seeing you soon.
Yes, take care, everyone.
Thanks,
Bye-bye.
Megan. Take care. Bye.